welcome to another edition of DadsDivorce. Today we have with us Mike Doherty, who is part of the Children's Rights Council of Illinois, which is a statewide group of concerned parents committed to improving the responsiveness to the needs of children of divorce and separation. Children's Rights Council of Illinois is an incorporated not-for-profit organization and the designated Children's Rights Council affiliate for Illinois. Mr. Doherty, I appreciate you taking the time out of your busy schedule to be with us today.
Oh, thank you. I'm glad to be here.
Could you just briefly explain the organization that you're a part of?
Well, we are the state chapter for the Illinois state chapter for the National Children's Rights Council, and it's a nationwide organization based in D.C. As the Illinois chapter, we started this about a year and a half ago, and we have several program goals, but one part of those goals is education of stakeholders, people in the divorce industry about current research that we feel they need to be more well aware of. And then we also have a parents network that provides sharing of best single parenting practices. And then we have some other objectives for helping to promote awareness and funding for various public programs that are friendly toward the needs of children of divorced parents.
Before we went on the air, you and I were discussing that you just recently gave testimony. Could you explain to the people who are tuning in, the people who are listening to the podcast, exactly where the testimony took place and what was the basis behind it?
Right. The legislature of Illinois, the House, put together a family law study committee, and so they authorized this committee be formed made up of some family law attorneys, some nonprofit organization leaders, and some other interested stakeholders in wanting to move Illinois forward on revising its Illinois family law, which was passed back, last version was fully passed in 1977. There's been some few add-ons since then. And so they put this committee together, and part of the committee's process, the first stage of this, was for the committee to simply bring themselves up to speed, find out what is the state of the state knowledge base and information out there by national and state experts on the impact on children of divorce and what's going on with the whole divorce process and how it affects families. So they authorized a series of hearings, and these hearings were simply to bring in people from different perspectives so that they would have a balanced set of information to work from as they proceed in their deliberations as a committee, which at the end they will create a set of recommendations which will then go to the Illinois legislature for consideration. So this is actually they're authorized by legislation, but it's a non-legislative committee of industry experts that will form recommendations.
Sure. And we're here to more educate our listeners who are primarily fathers as to what their rights are, what is going on, especially in the state of Illinois, and how can they achieve those rights. So going back to what you were referring to about the testimony that you gave, what were some of the major issues, in your opinion, that were discussed and that were brought to the attention?
There were a lot of different issues discussed in the course of these three hearings. These hearings lasted 6 hours and 7.5 hours in length. In locations where one was held in Springfield, one up in Waukegan, Illinois, which is the one I provided testimony at, and then one in downtown Chicago last Friday. And in these hearings, they had, there'd be 10, 12 different or more subject matter experts from different disciplines and different real-world backgrounds and experiences that testified. And so the part that we came in on was to point out that although there's all sorts of different issues out there, we really need to do something about closing this gap, this widening gap that is occurring between a de facto visitation schedule that's a de facto standard visitation schedule that is followed in Illinois across most of the family courts. Everybody knows it exists, even though it's not authorized or written down anywhere other than in the judge's protocols. And we have found actually written verification that it does exist. But and it's also reported on attorneys' websites as well. So people know it exists. There is verification that it exists, but yet officially there's no actual guidelines for the judges as to what a visitation schedule should look like in terms of the actual parenting time.
Now I'm going to interrupt real quick for the people who are listening and who are maybe not familiar with this de facto visitation schedule. Can you explain what that is?
It's every other weekend and 4 hours on Wednesdays. And
so it's not quality time at all.
Well, it's the every other weekend is your overnights, and that's throughout the school year, 9 months. And then during the summer, it's 2 and maybe 3 weeks of quote-unquote vacation time. And that's what the non-custodial parent is most likely to walk out with, even if they're fit, even if they live in the same school district. They're going to be their parenting schedule for the remainder of their child's life till their child's 18 years old, unless the custodial parent agrees to something more than that, which many custodial parents do, but not all of them do. And where we're coming from is that the research that we have uncovered and we've read through carefully, and we're sharing with judges and we're sharing with GALs, and they are aware of this research, over the last 5 years has clearly substantiated that an every other weekend overnight schedule for a non-custodial parent's relationship with the children is insufficient to protect the child's best interest. It is, in the words of one of the most nationally recognized psychologists on this subject, it is child-unfriendly schedule. So that is why we feel, since the buck stops on the judge's desk, everyone bargains in the shadow of the law, that kind of a standard needs to be brought in line with the current social science.
And this is regardless if the non-custodial parent is ready, willing, and able to spend more time with their children.
That's correct. In effect, it appears to be a virtual ban on school overnights. Now, some judges are quick to point out, but sometimes we do award school overnights. Well, we challenge them to say, show us the percentages, because
Sure.
Our records show it's a rare occasion that happens.
Now, are you familiar with what has been termed the approximation rule?
Yes, and we have, actually one of the nationally recognized psychologists I'm referring to, Joan B. Kelly, has, in her research studies, she points out that the approximation rule isn't necessarily a very good idea, because what that is, we are very familiar with it. It's where courts attempt to figure out how many hours per week the parent was engaged with the children for 48 months prior to divorce, and then they lock that parent in for the next, possibly 10 years on that sort of a schedule, or 15 years. Now, those who talk about the approximation rule and want to use it are quick to point out to me, and others will say, no, we're not locking anybody in. We'll come back and revise that. It's only temporary in for like a year, and then it'll be revised. Well, we all know that there's nothing as permanent as a temporary order, and it seems to us that it doesn't take into account the dynamics of the post-divorce family and the children's needs, because it's framed on the basis of what the children's needs were prior to divorce, which is a whole different family structure.
Exactly. And when you say that they come back and modify it, do they do this on their own, or does the non-custodial parent have to hire an attorney, pay the money, and have it basically reheard again?
And that's the problem with it. It depends on how this approximation rule would get implemented. It could, unless you really have an aggressive program of encouraging parents to come back in, we all know that once those visitation schedules get set, that under the current system for modification of visitation in Illinois, you're facing with a rather stiff uphill battle to get those modified, to get those changed. So
right.
Now there's aspects of the approximation rule that, if you had a parent that was totally disengaged, I don't want to just completely diss it. There are aspects of it that maybe should be looked at and are reasonable, but it's a matter of degree. And if you have a parent who's barely engaged at all with their children, and then suddenly you're going to take that parent and